My name is Loukas Mistelis. I'm the Clive Smith Professor of Transnational Law and Arbitration, and for many years I've been responsible for developing our LLM offerings in dispute resolution. So the module I would like to talk about briefly today is investment treaty arbitration. Investment treaty arbitration is a very specialist subject, and we have been one of the first places in the world to offer a module on that topic. It particularly addresses cases where investors may bring a direct claim against the government, even in cases where the investor did not have an agreement with the government, simply because the consent to arbitrate is given through an investment treaty, typically a bilateral investment treaty or a free trade agreement these days. So what we do cover is actually the life of the arbitration, from the beginning to the end. We look at the infrastructure, the regulatory framework, the evolution of the system. Admittedly, it's a post-colonial project, started around 1950s, 1960s. And then we look through the arbitration, how arbitration starts, how jurisdiction is established, key issues of procedure, and also quite a number of issues of policy. ISDS is widely criticized by civil society these days, and therefore we have to engage with that topics as well. It's also a very innovative way in which we examine this course. We don't want to sort of have replication of knowledge. So every student will have to write an essay of about 5,000 words. The first part of the essay is a practical exercise, very much like any young practitioner will have to do in their respective law firms, writing a case note to their superior, whether it's a senior associate or a partner, explaining in 2,500 words what an award says in 150 or 200 words. The second part is writing a blog post in relation to that case. Is not what happened in the case, but is what is the context and the implications of this case. And therefore, I think we offer a practical written assessment which the students can choose themselves. We don't impose the topic, but also gives them an opportunity to develop a skill of communicating their knowledge to their peers. So we are offering sort of a number of interactive classes, as well as tutorials, of course. And in interactive classes, we focus primarily in ICSID, the International Center for the Settlement of Investment Disputes, which is part of the World Bank and is headquartered in Washington, D.C., but cases under ICSID can be heard anywhere. But we also look at other cases which don't fall under the auspices of ICSID, but fall under the auspices of other arbitral institutions. So from initiation, jurisdiction, key procedural issues, all the way to awards enforcement, and as well, of course, we cover the current reform proposals, which have been for some time within UNCITRAL in Working Group 3.